I make these videos. I hope it doesn't seem like I'm just picking on people, but I make these videos because I see these guys get likes. So I'm assuming that other people have the same questions. I know that Mr. Balzania doesn't believe he has questions, but he does because he continually misunderstands. If you're wondering why it's so terribly easy for me to knock these assertions down, it's because they've been asked, they've been answered. It is very, very subtle case law, and I don't know how many times I have to run through it, but we'll keep doing it until it sinks in. You do understand the First Amendment makes a distinction between speech and the press. Yes. And you can see in Estes v. Texas, it is said, however, that freedoms granted in the First Amendment extend the right to the news media to televise from the courtroom, and that to refuse to honor this privilege is to discriminate between the newspapers and television. This is a misconception of the rights of the press. And then they go on to talk about it. And basically they say that, yes, you can go there and you can gather information. You can take notes. You can make drawings. You can talk about it later on the news. But you don't have the right to film in there. And again, it comes down to the primary concern of all must be proper administration of justice. The reason why I link these cases is so you can read them. Because I just give you a quick broad brush kind of go over on them. I'm not going to sit and take the time to read it, but this is on 359, or I'm sorry, 539. This is on page 539 that they talk about this stuff. So go read it. This is Rice v. Kemper. Rice v. Kemper. This is a Third Circuit case. I like this one because they're super on point, and they sum up a lot of cases that keeps me from having to go over it. Because we hold that neither the public nor the media has a First Amendment right to videotape, photograph, or make audio recordings of government proceedings that are by law open to the public, we find it unnecessary to decide whether executions must be open to the public. That tells you something right there. We hold that neither the public nor the media has a First Amendment right to videotape, photograph, or make audio recordings of government proceedings that are by law open to the public. While Richmond mandates criminal trials must be open to the public, no court has ruled that videotaping or cameras are required to satisfy this right of access. Instead, courts have universally found that restrictions on videotaping and cameras do not implicate the First Amendment guarantee of public access. So let's go back to your question there, Mr. Balzania. Do you understand that the First Amendment makes a distinction between speech and the press? Because I do, and I understand what that distinction is. You have a right to go to these things. Generally speaking, I mean, if the gallery's full, you don't have a right to get in. They have to make it open to the public, and if there's not enough seats for you, then sorry. But you don't have the right to film unless they allow it, in which case you have the privilege of filming and it may be removed from you. If I was to make a change, the first would be to stop lawyers from taking case law that look as close to it as they can, get it, and then use it. I think what he's trying to say here is he would stop lawyers from taking similar case law and applying it to the current facts. Well, that's what lawyers do. We make our best argument. If you submit a motion of law or a memorandum of points and authorities or something like that to a court, what you're doing is you're making an argument that the fact pattern in this case is similar to the fact pattern in this case. And so the ruling in this case should be similar to the ruling in your case. And opposing counsel is going to do basically the same thing. They're going to look at the laws, at the cases, and they're going to find cases that maybe support their position. And then the judge, because that's his role, is he's going to look at those two arguments and he's going to say, well, I think this argument is more persuasive than this argument. That is the point of it. You don't even understand the point of the system, how an adversarial system works. Then he says, hey, this case has a First Amendment part in it that has nothing at all to do with freedom of the press, but fuck it, it's close enough that's run with it. So the problem, Mr. Balzana, is that the courts really haven't ruled much on freedom of the press. Does it exist? Yes, but we don't really know what it is. It's one of these nebulous things that exists, but we don't know in what way, shape, or form it will actually provide you with some level of protection. We know the courts have ruled that there's no requirement that they allow cameras in the court. So if you try to make an argument, well, what about freedom of the press? They've talked about it in Estes v. Texas. They talked about it in slightly different terms, but they said that, you know, that the news media to televise from the courtroom, etc. They've dealt with it. It's been dealt with. It's been asked and answered. So I actually think the reason why they didn't approach it on a freedom of the press angle, because that's more freedom of association. That's more, you can talk to people. You can ask them questions. You can investigate. The court and the police can't stop you from talking to witnesses, from doing investigations and things like that. That doesn't mean that they can't stop you from filming in a courtroom. If you have the right to film somewhere, then there should be no issue with you filming the police from that position, because you have the right to film there, and the courts have held that you can film the police when they're engaged in their official duties, if you're in a place where you have the right to film. They call it public, but what they're really saying is either a traditional public forum or a place that's open to filming. And if you have the right to film there, then you have the right to film the police there. And then Common Joe goes on with, what if a legitimate government interest was to use fear for political gain? It's not. I can't believe that you would even ask such a stupid question. What if it's to steal? Again, that's not a legitimate government interest. Notice the word legitimate in there. Is it a government interest to use fear for political gain? Sure. Is it a legitimate one? No, it's not. Words have meaning, Joe. Decorum of the court, lol, you're joking, right? No, I'm not joking. It's a legitimate government interest. You could be held in contempt if you don't rise when the bailiff says I'll rise. It's been done. I'm not joking. There is a decorum requirement for the court. If you go to the Supreme Court, you can't wear any badges or buttons or ID tags. You can't dress in a flamboyant manner. You can't bring any electronic devices with you of any sort. They're very particular. You have to maintain the decorum of the court. Every lawyer is licensed by, and most are paid by, the fictional entity called the state. Every lawyer is licensed by the state. That's why there is no such thing as a non-bar lawyer. And I don't think that most are paid by the state. I think most are in private practice or working for businesses. I know that you have a very, very narrow view of things. But criminal proceedings, while there are a lot of criminal proceedings, number one, not all lawyers that are engaged in criminal proceedings are working for the state. And I would say that the bulk of legal proceedings are not criminal proceedings. And a lot of lawyers don't even ever show up to court. They just work for companies and things like that, reviewing contracts and etc. So yeah, there are a lot of lawyers out there. I am by no means a rarefied class of people, which also happens to be who's making the accusations. Yes, the state does make accusations. Why not just put the prosecutor's name as the accuser? Because, Joe, the prosecutor's not the accuser. The prosecutor is representing the accuser. His client is the state. He owes a duty to the state because that is his client. Just like as if his client was an individual. And the state can substitute attorneys in for that prosecutor or whatever. It is not the prosecutor who is the accuser. It is the state. The prosecutor has no personal vested interest in it. The state does. The people aren't hurt by others not wearing their seatbelts. Okay, that's a non sequitur, but All right. I agree. I'm not a fan of seatbelt laws. You could make a rational argument for them. If you were truly an advocate, you would be out there advocating for the things you believe in rather than begging for internet dollars and making videos trying to drive money in. True, if you were truly an advocate for it, you'd be writing your Congress people, you'd be running for a state assembly position or whatever, so that you could enact legislation in Texas that would remove the requirement to wear a seatbelt. Now, I know you don't understand this, but there are always big balls of yarn behind these little threads that you're trying to pull. And one of the big balls of yarn is that the state requires that certain hospitals take accident victims into their emergency rooms. And part of that understanding with the hospital is that if that accident victim is not covered by private insurance, then the state will cover the cost to the hospital. And the state has a strong interest in reducing its bills. It does not want to pay for all the uninsured motorists who end up in the hospital, people without health insurance. So there's a couple ways that it goes about dealing with that. Number one, it may require people to have their own insurance. That's a legitimate power of the state. It's in their policing powers and they can do it. Now, do you agree with it or not? That's up to you. You can make a rational argument for or against it. But another thing they do to reduce their liability is to require that people wear seatbelts. They do that to reduce their liability. If you think they are out there generating income on this and you have no idea how much it costs to have police and all the insurance that's required to have those police and to maintain the vehicles of those police and to have all the background bureaucracy that's required to run those tickets and all that sort of fun stuff, the dispatchers, the people who are doing the background checks and maintaining the databases and maintaining all the radio equipment and the servers, the judge, the court clerk, I mean, paying for the buildings and the shops and all. It is incredibly expensive to have a police force. No state is making money off the police. No jurisdiction, no municipality is making money off their police force. If you go into any city's books, the police are a net loss. This is just one example. Insert most nonviolent victimless crimes. And again, you can make some very good arguments for many nonviolent victimless crimes like prostitution or the solicitation of prostitution. I don't believe they should be crimes. And you could make a good argument. Like you could say, well, if you make prostitution illegal, then prostitutes, they do it anyway. We know that. But they won't seek help if they're abused by their pimp or by their John. They won't get tested because that might expose them to, the police will figure out this person's getting tested all the time. So, so maybe they don't get tested all the time. And it doesn't work. So why would we do it? So you can make a rational argument for it. And of course, if you've gone to law school and you understand how to play devil's advocate, you can also make a rational argument against it. Well, prostitution brings down property values. Prostitution brings in crime. Prostitution brings in drug use, and drug use brings in crime. Prostitution is unsightly and unseemly, and it offends the people in the community, et cetera, et cetera. You could make a rational argument against it. And which way you want to go is up to you and your morality, and that's fine. I would also, I don't agree with seatbelts. I wear my seatbelt. I would wear my seatbelt even if there wasn't a law requiring me to, because I'm not retarded, but I don't think you should mandate people wear seatbelts or helmets. If I'm on a motorcycle, I'm going to wear a helmet, but I don't think you should mandate somebody wear a helmet. I don't use prostitutes, but if someone wanted to be a prostitute, like what's the difference between hiring a prostitute and hiring someone to star in a porno? The only difference is you're filming one and not the other. Explain that to me. But, your mileage may vary. Reasonable minds can reasonably disagree. Why would any government official mind being recorded if what they're doing is proper? Well, apparently you missed the Three Stooges in Tucson because it can be disruptive. That's one reason. A second reason is that they may be dealing with information that's not open to the public. Number three is it may be distracting them from their official duties. But I guess, playing devil's advocate is not your strength. That's why you're not a lawyer. To everybody else, thank you very much for watching. Have a great day.